We've probably all made prank calls at some point in our lives, usually as children or teenagers, and it's usually innocent fun. But there are times when making harassing or annoying phone calls in the state of California can be a crime and can actually land you in jail. And really, when I talk about harassing phone calls, and this is Penal Code section 653M, when I talk about harassing phone calls, really it's even broader than that. It can include text messages, emails, Facebook messages, any sort of telephonic or electronic communication. And basically there's three types of harassing communications that would constitute a crime. First of all, if you use obscene language. Now that can include profanity, it can include sexually explicit talk of graphic violence. Ultimately, it would be for a jury to decide whether a particular communication was obscene. The second type of communication, harassing communication, that could be a crime, is if you make threats to the recipient to harm the person or their family or their property. So if you threaten to beat them up, if you threaten to burn down their house, if you threaten to steal their dog, any of these sorts of threats could be a crime under Penal Code section 653M. Finally, repeated phone calls regardless of the content. So if your ex-girlfriend breaks up with you, and for you it's not quite over, and you keep calling her, and she says, look, I don't want to talk to you, don't call me again, but you call her again and again and again, at some point you could be prosecuted. At some point that becomes the crime of harassing or annoying phone calls. Now, Penal Code section 653M is a misdemeanor, and somebody who's convicted could be sentenced up to 6 years in county jail. Now, this crime of making, harassing, or annoying phone calls is one where we see a lot of innocent people wrongly accused. And here at Shouse Law Group, we've represented many people over the years accused of this crime, and we've had a great deal of success in getting charges reduced or dismissed. And a lot of times we find that our client really had no intent to harass the person and didn't even think that the person on the other end would be offended or was being offended by the phone calls or the messages. Sometimes we find that the alleged victim just outright lied and accused our client of making phone calls that never occurred, and the victim was, or alleged victim, was simply making false accusations out of spite or jealousy or desire for revenge. Sometimes we find that there were in fact some harassing communications, but somebody else made them, not our client, and our client got wrongly accused and misidentified. And these sorts of cases are very defensible. We've had a great deal of success in getting these cases dismissed. I'm former prosecutor, now criminal defense attorney Neil Shouse. If you or a loved one has been charged with the crime of making, harassing, or annoying phone calls under Penal Code section 653M, we invite you to contact us here at Shouse Law Group. Let's hear the story. Let's see what we can do to get the charges reduced or dismissed.